Good morning and welcome to today's administrative meeting of the Maryland Public Service Commission. This is our first meeting in about 3 weeks. I want to apologize to those who came to the building on August the 7th to only find out that we had a complete power outage and we had to delay the docket of those items until today. So we are ready to go today. I'd like to turn over the floor to Commissioner Richard for an announcement.
Oh, well, thank you very much, Mr. Chairman. Yeah, I am really pleased to announce Catherine Fuston. Is she here? There she is, back there. She's going to be joining the commission today, and she'll be one of our executive associates. Kathy earned a BA degree from Salisbury State University. She also earned a Master of Education from University of Maryland. She's a fellow TERP. She also most recently worked at Clark & Anderson as an office assistant and a bookkeeper, and also at JBF Properties as a property manager. What I found also very interesting is that earlier in her career, she worked at the University of Maryland's athletic department as an associate director of academic support, where she counseled students on their progress to graduation and also helped keep them eligible to compete. And she also helped athletes with their coursework and major choices. So again, we welcome Kathy, and I encourage you all to introduce yourselves to her and make her feel welcome.
Thank you. So over the past year or so, the number one complaint that I've heard from a number of parties and public service companies that come before the commission is the number of copies that we require, 17 hard copies and an original. I recognize that a number of other PSCs and our federal utilities regulator have gone electronic. We're not going completely electronic today. But effective immediately, we're going to reduce the number of paper copies required from 17 down to 12. They'll be coming out of the expense of Commissioner O'Donnell's pile, but I'm just kidding.
Well, I'm happy to say I don't take any of my copies, so everything's electronic for me.
It is my hope that with time and technology and a longer transition, we will eventually go electronic, but this is a small step. We'll reduce the number of paper copies by 1/3, and hopefully we could continue that transition going forward. I would also like to recognize that public comments no longer need to file that many copies. In fact, they could use our new electronic filing system, and I would encourage any interested taxpayers, citizens, ratepayers, or customers to file electronically on our website. It's very easy. Once you log in and register, one-time registration, you'll be able to file as many comments in as many docketed proceedings as one wishes to do without so much as using a postage stamp.
I think that deserves applause too.
Save a few trees in the process. With that, Madam Secretary, well, we have minutes, don't we?
We have minutes.
Yeah. It's been a while since the last meeting. We do have minutes from the July 31st, 2019 meeting. Having reviewed those, all in favor?
Aye.
The minutes are approved. At this point, Madam Secretary, the consent agenda.
Thank you, Mr. Chairman. There are 7 items on the consent agenda. The first 6 items are all filings by companies designating weather stations in compliance with COMAR Section 2031-0305, and those companies are, number 1 is the Potomac Edison Company, filed its on July 10, 2019. Secondly, UGI Utilities, Inc., filed theirs on July 16, 2019. Third, Hagerstown Light Department, filed on July 22, 2019. Fourth, the Easton Utilities Commission, filed on July 23, 2019. Fifth, Washington Gas Light Company, filed on July 24, 2019. And sixth, Chop Tank Electric Cooperative, Inc., filed on July 29, 2019. The 7th item is Baltimore Gas and Electric Company, filed on July 19, 2019, Supplement 632 to PSC Maryland E-6, BGE's Retail Electric Service Tariff page. The company proposes to revise Rider 1 standard offer service for Type 2 rates effective September 1 through November 30th, 2019.
Thank you. Do commissioners have questions on any of these 8 items? Seeing none, is there a motion?
Yes, Mr. Chairman. For items number 1 through 6, I move that we approve the weather station designations for the purpose of determining whether there is an extreme weather period that requires restrictions on electricity service terminations under Code of Maryland Regulations 20.31.03.03 and 20.31.03.04. And for item number 7, I move that we accept the tariff revisions for filing with an effective date of September 1st, 2019.
Thank you. All in favor? Any opposed? The motions are approved. Madam Secretary.
Going to the administrative agenda, item 8 is Washington Gas Light Company, filed on June 21, 2019, an application for authority to issue up to $875 million of long-term debt, case number 9612.
Good morning. Lloyd Spivak for the Commission staff. On June 21st, 2019, Washington Gas Light Company filed application for authority to issue up to $875 million in long-term debt. Prior approval from the Commission pursuant to Public Utilities Article Section 5-203 and 6-101 is generally required before a public service company can issue stocks, bonds, or other evidence of indebtedness which are payable wholly or partly more than 12 months after the date of issuance. Under Public Utilities Section 6-102B, the Commission will authorize a public service company to issue bonds, stocks, or other evidence of indebtedness payable wholly or partly more than 12 months after the date of issuance if the Commission finds that the issuance is reasonably required to, among other things, construct, complete, improve, or extend the public service company's facilities, maintain or improve its service, discharge or lawfully refund its obligations, or reimburse money not secured by or obtained from the issuance that is expended for one of the foregoing purposes within 5 years before the filing of the application with the Commission for the reimbursement. WGL plans to use the new debt in 3 ways: to purchase new medium-term notes to pay notes due in 2019, to refund notes due in 2023, and to allocate $805 million to fund capital expenditures from now through 2022. The debt issuance will also serve to rebalance WGL's capital structure to keep the amount of equity in the capital structure below the maximum of 55% equity allowed under the merger conditions in case number 9449. Staff recommends that the Commission 1. Grant the company's request for authority to issue up to $875 million of long-term debt. 2. Direct the company to file annual actuals of Exhibit 1 of its filing, including the company's June 21st, 2019 filing, and modified to reflect reasonable detail pursuant to COMAR 20.07.04.02a by no later than 60 days following the completion of the company's fiscal year. 3. Direct the company to notify the Commission prior to future dividend payments, including the amounts and payment date. And 4. Direct the company to file reports as required by COMAR 20.07.04.02c.
Thank you, Mr. Spivak. Counsel for the utility.
Good morning, Mr. Chairman, Commissioners. John Dodge appearing on behalf of Washington Gas. I do have some comments, but before I embark on those, I'd like to introduce some of my colleagues who are with me today. Victor Donge, for the public records, that's D-O-N-G-E, from our Treasury Department, is here to answer any specific questions you may have. You're familiar with Jim Wagner from our Rates and Regulatory Affairs Department. He's with me. And I'm pleased to introduce publicly Karen Hardwick, our still relatively new General Counsel from Washington Gas. She's here with us today. I'd also like to note thanks and recognition to Secretary Romine for getting the word out on the canceled admin meeting a couple of weeks ago. I was literally on my way to my car to head up 95 when I got her welcome message not to do that. So I'd like to thank her publicly for that effort. At the risk of making a mountain out of a molehill, Your Honor, the company is appreciative of staff and OPC's support of the approval of the request for the new long-term debt ceiling. But we do have significant concerns about the extra reports that they have suggested in this matter. Our request in this case is simple. We seek your approval to issue new long-term debt. The record in this case is equally simple. It's what you have before you. It's less than 40 pages. It includes our application and exhibits per Public Utilities Article 6-102, the COMAR requirements, confirmation that the company has provided the requisite newspaper notice of today's hearing, staff's comments, and to which are attached our responses to their discovery, and OPC's comments. That's the sum total of the record in this matter. Respectfully, there is no indication from the record of this case that any additional reporting is required. I'd like to start with the staff's buck sheet at page 3, which includes this sentence. Staff notes that the company has not provided staff with details regarding capital expenditures and working capital requirements in reasonable detail.
Excuse me, Mr. Dodge, where are you reading from?
That's the staff comments on page 3.
Page 3 where? I'm on page 3, but
The second full paragraph that starts, if the new debt is issued, it's midway through, and the sentence starts, however.
thank you.
Surely. We disagree that we did not provide the required information under COMAR and PUA. We filed exactly what those authorities require. It's the same thing that we filed in cases 9105 and 9356 in 2010 and 2014. I know that because I essentially copied and pasted the applications from back then. We answered all of staff's discovery and on an accelerated basis at their request. In fact, if you'll note in their batch of exhibits, in our response to staff DR number 1-4B, we actually offered to provide additional information to staff. Staff's claim has consequences. Our potential lenders and our rating agencies may well ask us, what information did you withhold from staff? I'll have to show them the record in this case. That's what I can show them, which shows we didn't withhold any information from staff. We met PUA and COMAR requirements, and we answered all their discovery. Next, staff's suggestion that the company notify the Commission prior to future dividend payments is not supported by the record in this case. This case concerns approval of a new long-term debt ceiling, not dividend payments. Dividend payments are governed by Condition 49, adopted in case number 9449, our merger case. Staff's reporting requirement here goes beyond the Commission's requirement in case number 9449. OPC adds yet more reporting requirements that are not supported by the record in this case. OPC asks for documents related to the debt issued pursuant to the new financing authority, documents detailing the process used to secure the debt, and updated overall long-term debt costs once the debt issued is in place. And their justification is another condition from the merger case, condition number 41. In fact, OPC relies and cites on that in its comments. That condition requires AltaGas, Washington Gas Light Holdings, and Washington Gas Light Company to hold Maryland customers harmless from the effects of the merger. The companies are in full compliance with Condition 41, and there's no evidence in this case to the contrary. OPC's recommendations go beyond what the Commission required in case number 9441 and 9449 and Condition 41. The company urges the Commission to approve the application before you and reject the additional reporting requirements recommended by staff and OPC. They are not warranted by the record in this case. I'm happy to entertain any questions.
Thank you, Mr. Dodge. I'd like to hear from OPC as well, but Mr. Spivak, can you respond to, I counted 3 arguments Mr. Dodge made with respect to the reporting requirement.
In the first instance, if you look at Exhibit 1 of their filing, which is basically the total amount of detail we have in terms of what they intend to use these funds for, it's not very detailed. It doesn't explain much of anything. What you have essentially is the company saying it will use $805 million of this debt issuance for capital expenditures. We don't have any idea what those capital expenditures will ultimately be. We have certainly been a lot more exacting in terms of detail on capital expenditures and what's happened in the Stride cases, and that's kind of what we're looking for here. More information about how they actually expend the money. So that's the first issue, and it's not exactly that burdensome. With respect to the issue of the record of this case versus the merger case, 9449. The fact of the matter is you can't view the merger case completely in isolation from almost any other financial happening that happens with WGL in the aftermath of that case, because all of WGL's financial transactions, or almost all of them, are going to be related in some way, shape, or form to one of the merger conditions, particularly the merger conditions that are designed to protect ratepayers from the financial issues that affect AltaGas. And again, there was some concern on staff's part that some of the funding from this issuance might actually be used to fund dividends, and we were not entirely sure that we were satisfied with the prospect of using debt to fund dividends, although we do understand that that may be necessary in some way, shape, or form in order to rebalance the company's capital structure and keep it within the limit that the merger requires. So that was another issue. And ultimately, what we're looking for is to get some reasonable detail on how the debt issuance is actually expended.
Thank you, Mr. Spivak. I'll have a question on the dividends in a moment from Mr. Dodge, but I'd like to hear from Office of People's Counsel if they have anything to add.
Good morning, Mr. Chairman, Commissioners. Joe Cleaver on behalf of OPC. Your Honors, as spelled out in our comments, we recommended certain additional reporting requirements associated with the company's request in this regard in order to ease the Commission's efforts as well as various stakeholders' efforts to ensure compliance with Merger Condition 41, which requires the company to hold harmless its customers from any increased costs of debt associated with the acquisition. Just two additional points beyond what we've set forth in the written comments, Your Honor, in response to what Mr. Dodge said earlier. Your Honors, the applicable COMAR Regulation 2742, subsection C4, which is the very last sentence of that regulation, provides that in order the Commission granting an application or any part of it shall contain such other provisions as the Commission may deem necessary or appropriate in each case. So the regulation envisions that there may be unique facts with respect to a debt issuance that may give rise for the need for additional conditions or additional requirements from the Commission. It's a catch-all phrase. Mr. Dodge's comments about this is a very simple filing and it's a small record. Well, this regulation contemplates that there could potentially be some additional requirement based on the facts, and this is a very unusual situation with this merger condition governing the company's cost of debt. Beyond that, Your Honor, with respect to the argument that there's nothing in the record in this case that concerns these merger conditions, I would agree with Mr. Spivak's comments. I would just also add that by their nature, a lot of these merger conditions they can't be extricated from what happens in subsequent cases. For instance, this Condition 41 requires the company to show that cost of debt that there hasn't been an increase in the cost of debt. Well, that envisions or contemplates something happening in a subsequent rate case in a separate case. And as a concrete example and a real-life example, the company has pending right now before the PULJ division a rate case number 9605, and there's an issue in that case regarding the synergy savings and the proper amortization and so on. So I don't think that you can look at the record in case number 9449 and say that it's somehow closed off and that things that happened in that case don't transfer to what happens with the company in subsequent proceedings, whether a docketed rate application or whether a matter before the Commission on the administrative agenda.
Thank you,
Thank you.
Mr. Cleaver. If we could bring Mr. Dodge back, then. I agree with Mr. Cleaver's last point that these cases, while separate, do have a level of interplay between them. I don't, on its face, find the reporting requirements unreasonable, but Mr. Dodge, trying to understand your argument, is this a question of burden for the company or liability or both? both or more?
Burden, and I'll cycle back to my prior comments and try to explain a little more. Of course, we can make filings if directed by the Commission, and we do that regularly. I can tell you what will happen if we start filing these new reports. They'll go into a rabbit hole, and in our next rate case, OPC or staff or another intervener will send us a data request asking for everything we filed. So they won't be put to use to protect Maryland ratepayers today or when we start filing. So there is a burden and an upward pressure on our cost of service that gets passed through those very same ratepayers, and I don't see a coincident benefit today of making these filings. Mr. Cleaver is exactly right. The context where this will come up is the next rate case, not in a debt approval filing. He mentioned that in our pending case 9605, there's some synergy and other issues. What he didn't mention is there's a short-term debt issue, and the company voluntarily adjusted its short-term debt cost downward by 32 basis points to make sure that Maryland ratepayers are not being burdened with the credit downgrades for ALA and its affiliates, including the company. So that's where it's supposed to happen. It's not supposed to happen in a simple approval case like this. Can we do it? Sure. But what benefit is there to ratepayers, and where is it really going to be considered? It's going to be considered substantively in the next rate case.
With respect to the reporting requirement on dividend payments, do you envision that Washington Gas would use any of this debt issuance to make dividend payments?
I suspect so, and I think we said as much in one of the discovery responses. I don't know the level or the timing of that. It's allowed under COMAR and the Public Utilities article, but I don't have any specific detail on that.
On that point, with respect to dividend payments, why would it be inappropriate to have the utility provide a status report with respect to those payments?
Again, Your Honor, respectfully, there's no impact on the cost of service to ratepayers simply because we make a dividend payment. The Commission has put boundaries about when we can issue extraordinary and regular dividends in case number 9449. A reporting requirement is not going to enforce that condition. The condition is self-enforcing. The Commission has jurisdiction under its general authority, under case number 9449, which, unlike Mr. Cleaver's implication, is open. It remains open so that you can enforce those conditions.
Mr. Spivak, how would you respond to that? It's still an open docket in 9449. Can we act through there if we see any problems?
It is an open docket, and certainly things can be filed in that docket and or acted upon in that docket. But in this case, we're dealing with a discrete act, which is the issuance of $875 million of debt. And it is within the bounds of this case as well. And I mean, part of what we are trying to do here is essentially exercise a bit of oversight over what happens with this debt issuance, and to cross-check it against the merger the merger conditions. You could do it in either case, I suppose, but it's perhaps a little more discreet if it's done in this case. As to what Mr. Dodge had to say about the disposition of the information in the reports that might be provided as a result of this discussion now, it's possible he's correct. It's also possible that we might see something in those reports. They will be looked at least when they come in, and to see what's in there. It's possible that nothing further will be done with them because nothing will be needed to be done with them, but it's also possible something might catch staff's attention and cause staff to initiate some sort of discussion with the Commission or with the company and OPC or all around.
Thank you.
That's what I would say at this point.
Do commissioners have questions? Commissioner O'Donnell.
Thank you, Mr. Chairman. Mr. Dodge, I wanted to ask you, you seem to be saying we shouldn't ask what this money's going to be spent on, what this borrowing is going to be used for, beyond what you've submitted. And that's my kind of distilling of what I think you said. But why is it inappropriate for this commission, if you're asking us to authorize your company to borrow $875 million, why is it inappropriate for us to ask what you're going to spend it on beyond the restructuring, debt, obligations, and capital expenditures, and that's all we get? Why is it unreasonable for us to ask that? A very simple kind of question.
It is not unreasonable.
Okay, thank you.
And you can ask it, but to your first point, there's a presumption that we're going to not tell you. And the time to ask us would be in the rate case when it has an impact on ratepayers.
So approve it now, and then you'll tell us later what you spent it on? Is that what you're saying?
That's essentially the way that the Public Utilities article is set up. You
I don't think
approve-
so. I think we have the authority to ask this question now. You just admitted to that.
And I don't think what I'm saying is inconsistent, Your Honor. The way that Public Utilities article is constructed, we come to you for authorization, and we're not going to issue all $875 million at once. It's going to be in tranches over the next 4
I
years.
get it, but look, if we're doing our due diligence on behalf of the ratepayers in your utility service area, your monopoly service territory, we have a right to ask what you're going to spend the money you're borrowing.
Absolutely, and we will respond in full.
Okay, that's as simple as that for me.
If I might just add one comment, I've been handed Comar here, and I just wanted to call the Commission's attention to Comar 20.07.04.02A3, which this is pertaining to applications for authority to issue stocks, bonds, notes, and other evidence of indebtedness. And A3 requires the application to have, if the purpose is for the construction, completion, extension, or improvement of facilities, the existing facilities shall be set forth as well as those proposed. And that information is actually supposed to be contained in the issuance, in the request for the for authorization to issue debt. It's not here, other than the Exhibit 1, which is very, very general. And so we did not think that asking for that level of detail with respect to the actual expenditures was asking too much.
Thank you. Commissioner Richard.
Actually, I was just going to ask specifically about the Comar provision that was just cited. It does appear that, in a sense, hasn't the Commission already been somewhat, I don't want to call it lax, but just rather open on these applications? Because, at least I'm reading it, it appears that it anticipates all the information will be available before we accept the application, for, all the different uses. And then it says, it wants information about the purpose of an acquisition, and then it goes into a lot more detail, or the purpose of construction, or purpose of the use of, paying off other debt instruments. So, in a sense, I'm a little surprised actually to hear your argument today, because I initially was thinking that what the staff were asking was very reasonable, to just ask for annual reports on what is being used. Because it sounds like, if I'm reading your application correctly, or at least your filing, you intend to have request a shelf registration for an amount of that money to be determined. It's used to be determined in the future. So can you just help me understand at least your interpretation of the Comar section that was just cited?
There are 3 responses. First, we're following the Commission precedent. If you choose to change it here today and impose reporting requirements, as I said before, we will follow that new precedent. Second, we did provide backup information in our other exhibits that lead up to Exhibit 1. And as I said before, if you order us, direct us to supplement Exhibit 1, we will file that information. But you also have before you information on how the company is going to spend this money. If it's okay to look at case number 9449 and say, well, we're going to interleave that with this debt application, I suggest respectfully it's okay to look at case number 9486, Stride 2, where we've given you great detail and actually obtained your approval for a 5-year program, and on an annual basis, we get your approval on a project list on where this money is going to be spent. So I don't think there's any deficiency in the information that the Commission has before it right now, or that you could request in the context of a rate case.
But I'm asking specifically about the Comar. I mean, I don't want to read the whole thing, but here it appears we could be very strict in asking for very detailed information on the uses. if we wanted to go that direction. I mean, there's an agency note that really, it's like 5 lines long in detail. So, again, I'm just trying to understand why what the staff are proposing and
Well, I
OPC
don't think I
proposing
used-
is unreasonable.
If I may.
And I'm
I
hearing
don't
you
think
say
I
it is
used
unreasonable.
I don't think I used the word unreasonable. I
Okay.
said it was not indicated by the record in this case. And some of these arguments are new to me this morning that the staff is raising. They're not in their comments. They weren't implied or expressed in their discovery. We've been doing what we did before and what other utilities coming before you have done. If you want to change that and order all of these reports, that's fine. It won't change our opinion that they're not necessary and that they don't benefit ratepayers in the immediate term.
Okay, and I guess my last point would be just, this is the very first application that the company is making since the merger, and there are these merger conditions, and I think, at this point, if you, specifically respond to staff, for them to get the information, there is always this asymmetry in the information flow, and that's why the reports for oversight are necessary. Why, again, would you find it, I guess burdensome for the staff to exercise their right to have at least these reports?
The staff, OPC, and the commission always have independent investigatory authority, independently and in the structure of a given case, to ask for information. Our point is, do it in case number 9449. Don't burden this case with these unrequired reporting requirements.
Okay, well, thank you for those responses.
Commissioner Linton.
Thank you, Mr. Chairman. So just following up on your last point, Mr. Dodge, why is there a different impact on the company if the commission were to grant the request of OPC and staff for the reports that they're seeking in case 9449 versus in the instant debt request that the company's made now? I mean, it'd be the same reports, go to the same staff. So what would be the difference? Why would it be a different situation?
It just makes this docket cleaner when we go out to potential lenders. We don't have it on the record in this case that we were insufficient in the provision of data. It more naturally fits under 9449. So is there an extra burden? I don't see a material difference in the burden between the two cases. I'm trying to keep the record of this authorization as clean as possible to get the best terms that are then flowed through to Maryland ratepayers ultimately.
So when seeking that debt from the lenders, the company wouldn't have a duty to disclose the reporting requirement issued in 9449?
Absolutely, Your Honor.
Okay.
If it was adopted, obviously. Yes.
If it was directed, if we were directed to happen. Okay. Thank you.
Commissioner Herman.
Thank you, Mr. Chairman. Mr. Spivak, has the staff recommended these types of conditions in debt issuances before?
I'm not aware of any specific occasion when it has happened. I think in this instance, it's really kind of the confluence of the merger conditions with the debt issuance and the specific financial conditions of affecting Alta Gas that really kind of led us to think about that. There's also, maybe we were kind of missing the obvious with respect to the money being expended on the projects that are on the Stride 2 projects list. But that point has not actually been raised even in this docket. They didn't even tell us that much. So, I think when we saw just how little detail we were getting on the debt issuance and relative to the size of the debt issuance, and with this debt issuance relative to the size of their existing debt, we thought something a little more was warranted.
Okay, and in other applications for debt issuances, has there been more specific information provided, or has it been in the past previously more of a, we're going to spend it on capital and we're going to spend it on working capital and capital expenditures and so on and so forth, and without any kind of specifics as to what, we're going to spend this much on working capital and this much on Stride or whatever?
Commissioner, I think it's been very variable. I don't think the level of detail we get is usually that terrific. That granular.
Right.
But I think it has been at times a lot more than we've gotten in this particular instance.
Okay, so how granular are you looking to get then? I'm just trying to understand where, because I think that, in my view, I don't think this commission can say you should spend this much on here and this much on here, in terms of the inner workings of what the company is doing. That's reviewed in a rate case and not in advance of a rate case, sort of directing the way they should spend their money. They come back in, that's part of the arrangement, they spend the money and we decide if it's prudent, at least under our current rate-making policies. So what kind of granularity are you looking for that you don't have?
I think probably about the level of granularity that we do see in the STRIDE project list, at least the initial STRIDE project list, maybe.
That, so instead of STRIDE, you would get STRIDE plus whatever their capital expenditures that they're
Right.
not doing under STRIDE? That's
Um,
pretty detailed, Mr. Spivak.
That would be fairly detailed ultimately, but it is still, the level of information we're getting used to getting on capital expenditures. I don't think we're looking to tell them what they can or can't do on a prospective basis. I don't think we're ever looking to do that. Even during STRIDE, it would be very unusual during a STRIDE case for us to do something like that.
Right.
As you said and Mr. Dodge said, ultimately the prudence decision has to be made in the context of a rate case, generally after the fact.
Right.
And that's where we would want to keep it. But that said, it at least gives us a heads up of what we should be looking for or at
Right.
in that rate case.
Right. I guess I'm just a little confused. I mean, it seems to me that I envisioned when I saw your recommendation that it would be something less than what you would get in a STRIDE filing, because that's very detailed down to like what street and so on and so forth. So, it seems to me that is probably a lot more detailed than what you all would want to be looking at, annually or outside of a rate case, but
Well-
perhaps not.
Well, I have been actually reminded that for at least electric company debt filings, Choptank, Smeco, Pepca, and Delmarva have filed capital expenditure plans with their debt issuance requests. And that
That
might
wouldn't
be-
look like a STRIDE filing.
No, but it would be a lot more detailed than what we actually got here.
So
Than a line item that says capital expenditures 800.
I understand that. I'm just trying to understand, for clarity, if the commission were to approve it, what would Washington Gas need to do to get the information that you wanted without overburdening, you with, thousands of pages of materials like we might see in the STRIDE filing? Because it doesn't sound to me like that's necessarily what you're looking for.
No, I mean the capital expenditure plan level might be sufficient in that, but something that gives you more granularity than what we have.
Then a line item. Okay, fair enough. And so, would these reports allow you to do monitoring of merger conditions that you're not able to monitor without these reports?
I don't think so. I think it would simply, we could get these reports outside of this context if we really wanted to.
And how would you go about doing that?
We would have to do a data request. And since the company, we would probably actually do it in the context of 9449 and go at it through there if we really wanted the information there. We could do that.
Okay.
It's not impossible, but it would require a separate context. And meanwhile, we have this filing here, which we really felt was lacking in significant detail. And is at least interconnected with how well the company is satisfying the merger conditions.
Okay, thank you. Mr. Dodge, do you have any responses to Mr. Spivak's discussion?
None, Your Honor, other than to thank you for raising those questions.
Thank you.
Mr. Spivak, I got a question for you. Do we control when a public utility has to come in for a rate case?
We don't control it. They decide when to do it. You can impose costs and conditions and take actions on them that might speed or slow the process of when they decide to come in, but ultimately it is the company's decision.
Haven't we recently seen a public utility company in the state of Maryland not come in for a rate case for 25 years?
We most certainly have, Commissioner.
All right, thank you. I just wanted to make that clear. We don't know when we're going to get a chance in the next rate case. Probably sooner rather than later, but we don't know for sure.
If I may, I would respond gently, Your Honor, that we do have a STRIDE program, and under the STRIDE statute, we're required to file a rate case no less than every 5 years.
That could be 5 years before we get the information.
Correct.
Thank you. Counsel for the utility, I don't think you've made unreasonable arguments here, and I am mindful of the regulatory burden on our utilities. By the same token, I do not believe, based on what I've heard, that either the requests of Staff Counsel or Office of People's Counsel is unreasonable, so I am supportive of the reporting requirements. At this time, I would ask for a motion.
Mr. Chairman, I move the Commission grant the company's request for authority to issue up to $875 million of long-term debt, direct the company to file annual actuals of Exhibit 1 included in the company's June 21st, 2019 filing and modified to reflect reasonable detail pursuant to COMAR 20.07.04.02 alpha by no later than 60 days following the completion of the company's fiscal year. And direct the company to notify the Commission prior to the future dividends payment, including the amounts and payment date, and finally direct the company to file reports as required by COMAR 20.07.04.02. Charlie.
All in favor?
Aye.
Any opposed?
Mr. Chairman, I oppose in part. I agree with the issuance. I think that the reporting requirements requested by staff and OPC are better suited for the merger docket and could be done by application or by data request or by request for the Commission in that docket. Nevertheless, I would say that in the future and in future debt issuances that some additional information would be appropriate to meet the requirements of COMAR.
Thank you. Your partial dissent is noted. Sorry, Commissioner Linton.
Thank you, Mr. Chairman. I also would concur with Commissioner Herman for the same reasons.
Thank you.
Actually, could I just make a statement too? Then, maybe staff ought to take a look at the filing application requirements in 2742, and maybe come up with some recommendations on what, if there are updates required, because it does seem that, all the requirements are there for a very, very thorough application. And if we're not going to, abide by that, or if we're going to, generally show some kind of, interpretation or, different way we might approach it with each application, we may want to flesh that out a little bit and just consider exactly how we're going to take these applications and what a minimum requirement, because I was very concerned when staff came back and said there was not reasonable detail, but it seemed that they were open to go ahead and proceed with the application with these reports. So anyway, I would just be interested to further that conversation about the COMAR requirement.
Okay. Mr. Spivak, you do not need to respond. Commissioner Richard, your vote is still to support the motion.
Oh, it is to support, but since
Okay.
other people were
Okay.
speaking up, I just wanted to make note of that.
Thank you.
I'm not going to make a statement, Mr. Chairman.
Thank you, Commissioner O'Donnell. The motion is approved.
Thank you.
Thank you, Commissioners.
The next item, Madam Secretary.
The next item is item 9, Potomac Electric Power Company filed on July 2nd, 2019, request for an extension to update residential service connection fees until January 1, 2020.
Good morning again, Commissioners. I don't believe this item will require much in the way of oral argument. This is a filing by the Potomac Electric Power Company requesting a waiver of a tariff requirement to update PEPCO's service connection fee for residential customers annually, and a tariff requirement to update rate schedule SSL-OH and SSL-UG. Those are two PEPCO's street lighting tariffs, fees for contribution in aid of construction annually. PEPCO has requested a waiver until January 1st, 2020. In order number 77409, issued in 2001 in case number 8844, the Commission approved PEPCO's current methodology utilizing the process of estimation and assessing the cost of residential service connections. The company's streetlight tariffs result from the terms of the stipulation and settlement reached in Phase 2 of case number 9217. When PEPCO last updated fees for service connections and contribution in aid of construction, the Commission directed the company to work with staff to develop metrics that both support and evaluate the variation between actual costs and estimated costs. That process is ongoing, and staff and PEPCO expect to complete it by the end of the year. Staff recommends that the Commission waive tariff requirements in Section 10E1 and Schedules SSL-OH and SSL-UG of PEPCO's tariff that require residential service connection fees and lighting customers, construction contribution in aid of construction fees be updated annually until January 1st, 2020.
Thank you, Mr. Spivak. Counsel for the company, do you have anything to add?
Good morning, Mr. Chairman and Commissioners. Matt Seegers, appearing for PEPCO. I have nothing to add, Your Honor.
Thank you.
Here,
Commissioner O'Donnell.
So when does this annual reporting stop?
I don't know that it actually does until the Commission makes an order otherwise.
So it goes on in perpetuity, on an annual basis,
Well, it's
until we change the order?
until you change the order, and it's not just reporting. I mean, they're actually, the fees
Changing,
and rates are actually changed
Changing, right,
annually.
right.
So,
And Your Honor, I'm sorry, just to clarify, it is stated in our tariff that we will file, that the fees will be updated on an annual basis. So until our tariff is changed, it goes on indefinitely.
Okay. Okay, I'm just trying to think in terms of the settlement, what that means, why it was instituted originally, and how long it was envisioned to go on for.
well, I mean, the issue is always going to be there, and there has to be a resolution of it. The existing resolution from case 9217, that was phase 2 of a rate case, and that came into effect then because the affected parties, I think it was Montgomery County and may have been PG County as well, but I'm not sure. But street lighting customers made their voices heard in those cases because they had an interest. And in the future, if that interest changes, I'm sure they will make themselves heard again, and that would lead to a similar type of change.
Okay, I'm satisfied, thank you.
Mr. Spivak, as part of the discussions, I guess as a preliminary matter, the existing tariff rates will continue to stay in effect until the update.
That's correct, Commissioner.
So are we expecting that the next update will result in a lower fee, or are we thinking that the fee will be roughly the same? Or
It probably won't change that much, or it might be, it could go either way. I don't think we know precisely which way it will go, but it probably is not going to change more than a few percent, usually.
all right, thank you.
Just a quick question. Would this have any impact on the efforts across the state to convert street lighting to LED lighting at all? Will the uncertainty in rates, or are we overcharging now with the current contribution requirements?
It's hard to say for sure, but I can't picture it having that much of an effect. I mean, the tariff is the tariff, and it will change from time to time. There's usually, maybe a couple. There's not required to be more than 30 days notice for most of the time for those changes, although in practice it usually takes a little longer to process either a change in the street lighting rates or the service connection rates. But that change can always happen. If the change is simply put off by 4 months, it shouldn't make any real difference.
Shouldn't. Okay. All right. Thank you.
Is there a motion?
Yes, Mr. Chairman, I move we grant the company a waiver of the tariff requirements in Section 19E1 and Schedules SSL-OH and SSL-UG of its tariff that require residential service connection fees and lighting customer CIAC fees be updated annually until January 1st, 2020.
All in favor? Any opposed? The motion passes.
Thank you.
Thank you, Commissioner.
The last item on the administrative agenda is item number 10, Great Bay Solar 2 LLC filed on October 5th, 2018, request to extend and amend CPCN construction deadlines, case number 9380.
Good morning, Chairman, Commissioners. Michael Dean on behalf of staff. Item 10 is a filing by Great Bay Solar 2 LLC requesting an extension of the commencement of construction deadline specified in the conditions to the Certificate of Public Convenience and Necessity granted by the Commission in case number 9380 for the second phase of the project. By order number 87321 on December 30, 2015, the Commission granted a Certificate of Public Convenience and Necessity to Great Bay Solar to construct a 150 megawatt solar photovoltaic generating station in Somerset County, which noted that the project would be constructed in 2 phases. In phase 1 of the project, 75 megawatts of the facility were constructed and placed into commercial operation in 2018. Conditions to the Certificate of Public Convenience and Necessity require that the construction of phase 2 of the project commence by December 30, 2018, and in its October 1, 2018 filing, Great Bay Solar requested an extension of this deadline. In a November 1, 2018 filing, the Power Plant Research Program of the Department of Natural Resources notified the Commission that it would wish to review the Phase 2 project and the existing conditions, but that this review would take several months. To allow additional time for this review, the Commission in November 5, 2018 issued a letter order granted a temporary extension to the construction deadline to the Certificate of Public Convenience and Necessity until the date the Commission issues its decision on the request. On March 20, 2019, the Power Plant Research Program letter was filed notifying the Commission that it wished to modify certain conditions to the Certificate of Public Convenience and Necessity, but that it would require 60 days after the county completed its approval of the site plan for Phase 2 of the project. The Commission reviewed the status of this matter in an administrative meeting on March 27, 2019, and noted the filings with the temporary extension of the commencement of construction deadline still in effect. Following approval by the county of the site plan on July 29, 2019, the Power Plant Research Program filed its proposed revised conditions for Phase 1 and 2 of the project. These include a revised Condition 3 specifying the deadline for the commencement of construction, and which specifies that the Phase 2 construction must commence within 6 years of the date of the original Certificate of Public Convenience and Necessity, and that Phase 2 must be completed by December 30, 2021. Staff in its supplemental comments reviewed these filings, including the Power Plant Research Program revised conditions with the new commencement of construction deadline for Phase 2 of the project, and noted that the December 30, 2021 completion deadline should be reflected in the commercial operation date of the PJM Interconnection Service Agreement for the project. Staff recommends that the Commission approve the revised PPRP condition for Great Bay Solar Phases 1 and 2. Staff also recommends that the Commission include a requirement for Great Bay Solar 2 to file with the Commission a modified interconnection service agreement to reflect the new commercial operation date of December 30, 2021.
Thank you, Mr. Dean. Counsel for the Power Plant Research Project.
Good morning, Commissioners. Sandra McNamore representing the Power Plant Research Program. With me today is Bob Sadinsky. He's PPRP's project manager for this project. And on behalf of PPRP and the reviewing state agencies, Mr. Sadinsky has diligently coordinated with Somerset County and the applicant to develop revised recommended conditions that address the issues that have arisen regarding Great Bay Solar Project since it received its CPCN in December of 2015. Mr. Sadinsky has also listened to and considered comments from the public, and after coordination with the county, incorporated relevant concerns into the revised recommended conditions. As a result of this process, as Mr. Dean just indicated, PPRP filed recommended conditions on July 29th, 2019 with the Commission and has since made 2 slight revisions to those recommended conditions. On August 5th, PPRP filed revised conditions that further addressed public comments, and then on August 29th, PPRP made a single revision to make the conditions be more consistent with the site plan filed by the applicant on August 13th.
August 19th, I believe, was the date of that filing from PPRP.
Yes, Your Honor, correct. The applicant has agreed to accept each of the conditions that PPRP are recommending at this time, and also Mr. Sadisky is here if you have any questions for PPRP. Also, I would like to note that Mr. Doug Taylor, the County Administrator for Somerset County, is here, and also Ms. Kristen Twombly, Assistant Director of Somerset Department of Technical and Community Services. They have traveled from Somerset County today, and Mr. Taylor has indicated that they would be happy to answer any questions you may have regarding the counties.
Thank you. If they could just raise their hand so we know who they are. Great. Okay. Thank you for coming down today. Thank you, Ms. McElmore. Are there other interested parties that wish to speak? Mr. DeClement, please approach. Mr. DeClement, is this the document you previously provided to us on August 5th?
I need 6.
No, this is a new document.
Okay. Mr. DeClement, as I mentioned last time, we cannot be accepting documents on the day of the hearing. If you recall, last time you provided us with all these color photographs, it doesn't provide the other parties an opportunity to review them in advance. We'll take a look at these now, but they won't be made a part of the record. Mr. DeClement, you may proceed.
The reason I give you this is this roads agreement was signed for Great Bay Solar 1 and a similar one, 15 pages, basically the same document has been signed for Great Bay Solar 2. These roads agreements pay the county $140,000 in Great Bay Solar 1, and from what I'm hearing, $85,000 in Great Bay Solar 2. The problem with this document is that this document takes out all impartiality for the permitting process, and this document then places the county under obligation to the developer to complete all the permitting and to meet all the conditions. That's why I passed that out, just for your brief information. I sent Mrs. Romine an outline, and I briefly want to go over that, and I will be brief. Currently, the county has approved a decommissioning plan of 80% salvage value, 20% a letter of credit or bond by the developer, the way we're understanding it. The problem with this is that there is no salvage value. I spoke with the Energy Program Manager, Maryland Department of Energy Administration, and there's only one place in the United States that takes these recycled panels. The panels have no value. There's 7 other locations that take the panel, but they're all shipped to one location in Arizona. The price per panel that the county would have to pay is $10 to $50, depending on where the panel was manufactured and depending on the materials within the panel. Therefore, the salvage value is basically zero. The only salvage value left would be the steel construction, the beams, and the chain link fence and the cabling in the ground, which would then be absorbed by the whatever construction company decided to take this down should this project fail. Citizens are asking for a decommissioning similar to what was proposed and enacted in 2016 on the Hagerstown site, where the state did a solar program and they're requiring
the developer at that time in 2016 to post an 88,000 per megawatt bond. That would be a true decommissioning plan. The decommissioning plan that Somerset County has now is basically putting the fox in charge of the hen house, because what we have is a decommissioning plan where the county will bear 80% of the burden, and the county will have to pay to dismantle the panels, have them shipped, and the shipping has to be hazmat certified, and the driver has to be hazmat certified because they're considered hazardous waste. So these recycled panels cannot be shipped unless they're hazmat certified. And then the county will have to pay a fee for the location in Arizona to take each panel. So this places a terrific burden on the Somerset County.
Mr. DeClement, just so I'm in the right frame here, aside from yourself, do you represent any parties?
No, just citizens.
So you're a resident of Somerset County?
Yes.
Okay.
Yes. So then so what we're asking for basically is that the decommissioning be revisited and that the developer be asked to post a bond for $88,000 at least. That was 2016 dollars. It should probably be more like $95,000 per megawatt, which would actually cover the decommissioning costs, as opposed to what is proposed now, which is not going to cover the decommissioning costs and will place a several $million burden on the county should the project fail. Secondly, the other issue is of course, the buffering. Great Bay Solar 1's buffer, they just mowed it over and put in the mitigated buffer in order to get Great Bay 2 started. I do have photographs, which I can show you, of the Great Bay Solar buffer after 1 year's growth. I've made 5 copies for each one of you who would like to see them.
Don't we have them already?
These are new ones.
New ones.
And these ones would be a little more informative than the other ones. The other ones were taken early last spring. These are taken basically at the end of the growing season. If you'd like to see them, they're here. I've made 5 copies. The issue is they use green giant arborvitae, which this year, which we have in photographs, has an average growth rate of about 5 or 6 inches per year. And the power plant research director, Mr. Bob Sadzinski, said that the project, according to the Public Service Commission mandates, must be fully buffered to a height of 8 feet, meaning not visible at all within 5 years. At the growth rate and with the type of plant they're using, this is impossible. And the only alternative to that would be a triangulated triple row of eastern red cedars, which spread and have a drip line, which is a diameter much wider than what they're using here. What they're using here, it would take 10 to 15 years, and they're highly susceptible to wind. Now, Somerset County recently passed a solar ordinance in which they have proposed only a single row buffer. Single row buffer is totally inadequate, and single row buffer will not adequately shield a project for almost for more than 50% of the life of the project.
Okay. Well, we'll hear from counsel for Great Bay on these points in a moment.
And lastly, we're asking for clearly defined consequences for noncompliance. Because in stage 1, there was noncompliance with the Maryland Department of the Environment. There was noncompliance with the roads weren't completed. There were safety issues with the roads, and there was certainly not a compliance with the buffer. So we're asking for some type of consequence for noncompliance, some type of penalty be assessed to the developer if there are Maryland Department of the Environment violations, if there are road issues, safety issues, and if the buffer is not completed according to plan, and that the decommissioning be looked at and some consequence be attached to that. And we would ask that these clearly defined consequences be looked at and be in place before construction begins. Also, the Power Plant Research Director had said that the buffer should be in place and established before construction begins, which would therefore affect the extension and the construction deadlines. That's all I have.
Thank you, Mr. DeClement. Any other parties wishing to speak? Do the representatives from Somerset County wish to make any comments? Okay, thank you. If you could approach either podium, Mr. Biegelmans will share.
Good morning, Mr. Chairman and Commissioners. My name is Ralph Taylor. I'm the Somerset County Administrator. It was nice seeing two of you in Mako last week in your Meet the PSC session.
Thank you for coming to
It
that.
was enjoyable. I did want to set the record straight on a couple of issues that were just brought up. The road use agreement has not been executed and is under review with our county attorney right now. So that has not been executed as was stated. And the decommissioning plan was just presented to the county Department of Technical and Community Services yesterday and will be under review and approved by them at a date. So that has not been approved yet either. I wanted to look at, there were some issues with Great Bay 1 that I wanted to bring to your attention today, and they are, as Mr. DeClement had brought up, the buffer issues on Phase 1 were inadequate when it was built, but the company has worked diligently with the county to make corrections of that, and they did put arborvitae green giants in, which we strongly feel will be a decent buffer in a few years. We've not been pleased with the general maintenance of the Phase 1 sites, mainly grass mowing. I think there are conditions that we've put together for the next phase of the project will address that and keep the grass to a height of no more than 12-inch maximum. So I think that will be fine. And the roads agreement, it's been mentioned many times that the roads, were not put back to standard or whatever. The roads were actually put back better than they were before. And the reason that they were held up was there was a court case regarding ownership of the roads that ended up, now it's in the Court of Special Appeals. The pleadings will be heard probably within the next few months. But I just wanted to let you know about the facts on those few issues. And I have Kristen Tremblay here with me. She's our Assistant Director of Department of Technical and Community Services. She can answer any technical questions you may have that I can't. And also, I did want to say that we've worked side by side with the Power Plant Research Program. Mr. Zazinski, they've been absolutely phenomenal to work with, and I think it's been a great partnership.
Great. Thank you, Mr. Administrator. Mr. Biegelmans, Counsel for Great Bay Solar 2 LLC.
Thank you very much, Mr. Chairman, Commissioners. David Biegelmans on behalf of Great Bay Solar 2 LLC. I have with me Christy Ramkasian from the project company, as well as Dane Bauer and Melissa Hall from H&B Solutions. They're the environmental consultants for the project. They prepared the environmental review document that was submitted for the addendum to the project and the extension request. Great Bay has reviewed staff's buck sheet and PPRP's revised conditions filed on August 19, 2019, and supports PPRP's revised conditions and concurs with staff's recommendation. We appreciate PPRP staff and the county's support for the extension request. We believe the conditions before the commission bring the conditions for this project up to date with the more recent conditions adopted by the commission for these projects. I have nothing to add to staff or PPRP's presentations. I would like to briefly address Mr. DeClement's comments. On the buffer issue, I believe the county administrator covered that well. I would like to add some detail with respect to the conditions before the commission today. There's actually two conditions that address the buffer, one for Phase 1, one for Phase 2. On Phase 1, there's a new condition. It's revised Condition 1, which requires the project to maintain the screening approved by the county. It's basically deferring the screening plan to the county, but the maintenance is incorporated within the CPCN. And it also sets a 8-foot minimum that must be met by September 2023. Mr. DeClement raised concerns about whether the green giants approved by the county would be able to grow in time. I think here there's a mechanism that requires the project to meet minimum height requirements, and if they're not able to, then obviously the county and the commission would have recourse. For Phase 2, it's effectively the same requirement as Condition 21. That condition also has a phasing requirement that requires the screening to essentially be installed at a minimum, as the panels are installed, and sort of keep up with the pace of construction to make sure that at least the initial screening is in place while the construction of the wider array is underway. With respect to the decommissioning plan, as the county administrator indicated, the county has a process for that. At the commission level, the project does have a decommissioning plan in place, and PPRP has proposed a condition that is condition 15 that requires the project to update that plan in conformance with the more recent requirements that PPRP has proposed and the commission has some experience with. So that deals with the salvage value issue and the financial mechanism guaranteeing removal. I believe the county administrator addressed the road issue. With respect to mowing, it's my final point. PPRP has proposed a revised condition that requires the grass be mowed under the panels to 12 inches. And my understanding is they worked with the county on that to clarify that requirement. Again, we have representatives here from the project company and their environmental consultants, and we're happy to answer any questions. And thank you for your consideration.
Thank you, Mr. Bugelmans. Do commissioners have questions on this project? Commissioner O'Donnell.
I want to ask PPRP a question. So the county administrator said that the decommissioning plan was pending approval of the Board of County Commissioners of Somerset County. What role does the PPRP have in approving that decommissioning plan?
Well, we need to go back a little bit. There is an active decommissioning plan effective right now that was submitted, my understanding, was submitted approximately in 2016. I took over this project in 2017 due to retirement, so I was not aware of that plan until probably about a year and a half ago. I was not aware that there was a decommissioning plan even submitted to the county until this morning.
Well, Commission 15 says this, Condition 15 says this, the applicant shall submit a revised plan addressing, and this is new language in your own revised conditions, addressing the decommissioning of both Phase 1 and Phase 2. The revised plan shall meet the requirements detailed in paragraph A through E. The GBS shall submit a decommissioning plan to the Public Service Commission, Somerset County, and PPRP. So I'm asking you, what is your role, what is PPRP's role in that decommissioning plan? You're saying you're not aware that there is a new one.
We did review the old plan. Mr. DeClement did call me, made me aware of the salvage value. It was only included in the first 10 years. And to be perfectly honest, I did not recall that. So I do appreciate his call. And once I reviewed that, that was after the submission. And so we corrected that in one of our filings, noting that the plan should be rewritten to our current standards, which does not include salvage value, unless it can be shown by the applicant that there is value in that.
Trying to figure out what role you have going forward in this plan approval.
Just to review.
Your answer is not responsive.
I'm sorry,
to that.
just to review? Yeah, down below.
Just to review it? You don't have
yes.
the ability to deny it, or?
I believe that's for the Public Service Commission.
Okay.
I saw Ms. McElmore standing up. Did you want to add anything to be responsive to Commissioner O'Donnell?
No, Your Honor, I think Mr. Saditsky just made
Okay. So we have final approval authority. So this revised plan, Ms. McElmore, can you clarify it for me? This revised plan that's somewhere in the process right now will be submitted to the commission for approval? Is that what I'm hearing?
I believe that's the case. Mr. Bugelmans may have a better answer to what they intend on doing.
So pursuant to PPRP's condition, there will be a revised plan before the commission for approval. It'll be similar to the MD Solar 1 and MD Solar 2 cases where PPRP staff can provide input. Obviously, the project companies will work with the state agencies to ensure compliance with the condition. And then ultimately the condition is approved, or the plan will be approved by the commission.
Staff council agree with that? Will this come before us again for approval at an admin meeting or some other forum?
It's my understanding that in other cases, decommissioning plans have come up before the commission after they've been filed.
Okay, I just wanted to clarify that because I was surprised to hear there was a pending decommissioning plan before the Board of County Commissioners that hadn't been approved yet. And then I started thinking about what are the downstream approvals required of such a revised plan. And it wasn't clear to me, it wasn't discussed, although it's kind of was discussed tangentially. Thank you all for clarifying that for me.
Additional questions from the commission? As I was looking over condition number 15, Commissioner O'Donnell does raise a good point, and it appears that after Somerset County's Department of Technical Services reviews the decommissioning plan, it will come before the agency for evaluation and approval by the PSC, including the creditworthiness and financial capabilities of the counterparties to the agreement. I do commend the county, the state agencies, including PPRP and Staff Council, for working together. I do think Mr. DeClement raises some good points. If I was a neighbor to Great Bay, I would want the property to be in presentable condition, to have the proper landscaping and foliage to at some point obscure the visibility of the solar panels. And it sounds like the arborvitaes should do that if they don't grow fast enough, or they will be in violation of their conditions. What did we say, 8 feet tall by 2023. Additionally, there are consequences, as you request, either by the county for violations or from this commission if Great Bay fails to meet the conditions laid out in the document prepared by PPRP. So I have full confidence that these conditions will be honored, and if they're not honored, there will be consequences for Great Bay. If there are no additional questions for the applicants, is there a motion?
Yes, Mr. Chairman, for item number 10, I move we approve the revised PPRP conditions for Great Bay Solar Phases 1 and 2 and direct Great Bay Solar to file with the Commission a modified interconnection service agreement to reflect a new commercial operation date of December 30, 2021.
Thank you. All in favor?
Aye.
Any opposed? The motion is approved. Having no additional business before the agency this morning, this meeting is adjourned.